Between 2019 and 2023, the Kentucky Board of Cosmetology increased the average fine against its licensed salons five-fold. The scale of penalties shifted in a few short years, moving from small regulatory fees to thousands of dollars per case. To many of the operators on the ground, this spike in enforcement was not random. A perception emerged that the board was focusing its resources on nail salons, particularly those owned by racial and ethnic minorities. This chart on the left shows the surge in fine totals during that four-year window. But when Kentucky's Legislative Research Commission audited the board in 2024, they found a paradox. Despite the complaints from salon owners, the data required to prove discrimination is currently impossible to find. The state audit confirmed that while the majority of complaints were directed at nail salons, a valid assessment of whether those salons were being disproportionately targeted could not be conducted. The audit failed because the board's own files were inconsistent. Fine amounts were not broken down by specific charges, and critical inspection documentation was often missing entirely. This administrative disarray occurred alongside a significant gap in oversight. Some locations had not been inspected since 2014, only to be hit with heavy fines once the board finally returned. There is credible evidence of a system that targets the nail sector, but moving from evidence to legal proof requires a standard of data that the agency did not maintain. When an agency fails to keep consistent records of its own actions, it creates a vacuum of accountability. In this case, the lack of documentation effectively prevented auditors from determining if the board had acted with bias. To see how this system functions, we have to look at the specific numbers behind the fines issued between 2019 and 2023. This chart tracks the average fine across 770 agreed order files. In 2019, the average was roughly $400. By 2023, it rose over $2,100. The extremes were more pronounced. The highest fine reached $10,000. While no fines exceeded $2,500 in 2019, by 2023, that amount accounted for over a quarter of fines. These penalties are governed by a specific statutory framework, Kentucky Revised Statute 317A.990. The law sets maximum limits of $1,500 for a statutory violation and $750 for a regulatory violation. Crucially, these limits are per violation caps, not total caps. The law doesn't limit the total amount the board can charge in a single enforcement action. This allows for a practice known as penalty stacking. By stacking multiple counts of $1,500 or $750 violations from a single inspection, the board can legally issue a five-figure fine. Because statutes allow for these high-dollar totals, the fairness of the system depends entirely on the agency's ability to document its math for every single charge. The audit found that the Board of Cosmetology failed to provide that documentation in its official agreed orders. Instead of an itemized list showing which dollar amounts were assigned to which violations, the agency routinely issued fines as a single lump sum. This lack of itemization was joined by a second failure. The board frequently lost the primary evidence of the violations themselves. Out of the 770 enforcement files reviewed by the state, 353, nearly half the files, were missing the original inspection sheet. When the primary paperwork is missing, there is no way for an outside auditor to verify the board's findings. Without an inspection sheet or an itemized breakdown, it is impossible to know what specific violations occurred during the inspection.
We cannot tell if a $10,000 fine was a correct calculation of multiple severe violations or an arbitrary number chosen by an inspector. By combining lump sum billing with missing inspection sheets, the agency effectively neutralized any attempt to check for institutional bias. Proving disproportionate enforcement in court requires a complete statistical picture, and that brings us to the denominator problem. The numerator of this equation is the data we can see, the fines, the complaints, and the salons being targeted. But to determine if those fines are disproportionate, you need the denominator. That means knowing total salons by type, baseline complaint volumes, and total inspections over time. This is where record-keeping failed. The board only maintained records of active licenses, discarding historical data on salons that closed or were penalized in the past. Without year-by-year counts of every licensed establishment in each category, researchers cannot calculate the actual rate of enforcement. Because of this missing data, the question, Are nail salons fined more often than hair salons? Cannot be answered with the current public record. If an agency does not record who exists within its jurisdiction over time, it becomes statistically impossible to prove it is targeting any specific group. Following the 2024 audit, Kentucky lawmakers passed several requirements to force the board toward better administrative practices. The new statutes changed the rules for how the board handles routine inspections and enforcement actions. The most significant change is the warning notice mandate. Under current law, an otherwise lawful salon must receive a warning notice first, unless an inspector documents an immediate danger to health and safety. The law also ties the board's disciplinary actions to stricter evidentiary standards of Kentucky Revised Statute Chapter 13b. Licensees are now guaranteed 30 days to answer a complaint and 30 days to request a hearing after they are notified of intended discipline. This creates a clear distinction between the board's internal meeting logistics and the due process rights of the salon owners. These reforms create a stricter legal baseline for the future, but they do not address the undocumented financial impact of the 2019-2023 crackdown. The history of enforcement at the Kentucky Board of Cosmetology is a study in financial escalation without a corresponding trail of evidence. Claims of racial or ethnic discrimination remain unprovable because the board does not publish the demographic datasets required to test them. While the original draft of Senate Bill 114 proposed collecting data on age, ethnicity, and country of origin, that requirement was removed before the bill became law. What we are left with is a complaint-driven system, rising fine severity, and structural conditions that make nail sector targeting look credible. However, a public case-level dataset does not yet exist to prove disproportionate enforcement with statistical confidence. For those seeking accountability, the next step is an aggressive open records campaign. This requires targeting the full enforcement universe from 2010 to the present, with a specific focus on the years between 2019 and 2026. The goal is to manually rebuild the denominator that the agency failed to preserve. Accountability cannot rely on an agency grading its own missing homework. It requires a manual reconstruction of the facts, one record at a time.